Joe Biden and Kamala Harris have vowed to take away your Second Amendment rights through gun bans, gun confiscation, and government regulations. Now, Joe Biden is no longer hiding his real intentions, and we need you to take action now.
Whether it's a 9mm pistol or whether it's a rifle is ridiculous. I'm continuing to push to eliminate the sale of those things. But
the Biden administration is coming after your right to own any gun. Joe Biden has already issued executive orders.
Hey everybody, welcome to another edition of the Daily Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, Alex Uli of the Uli Law Offices in Indiana, as he does every Friday. Alex, thanks for coming by today, man.
No problem, Paul. Thanks for having me.
So let's get started. And what I want to start with is your home state of Indiana, and found a couple stories this morning. One story is that constitutional carry is advancing in Indiana, but if you've got alcohol issues and maybe have a couple of DUIs or something, or you've been arrested for misdemeanor drugs, you may lose all of your gun rights, not just you won't get constitutional carry. The other one says it's going forward without amendments. Which is what? What's going on, man?
Yeah, so there are two bills primarily, one that's originating out of the House and the other out of the Senate. And the one that originates out of the House is, in my opinion, a much better bill. It doesn't have, first of all, it doesn't have an age restriction like the Senate bill does. The Senate bill says that constitutional carry would only be for those 21 years or older. So if you were between the age of 18 and 20, you would still have to get a license to carry a handgun in Indiana. And the House bill doesn't have that requirement. Also, the Senate bill has what you were just discussing, the alcohol abuser language and this other prohibitive language that would exclude certain categories of people from possessing a firearm. The House bill does not have that kind of language. So the House bill, in my opinion, is a much better bill, and in fact has already passed out of the House and passed out of the House overwhelmingly. So the House bill, it's House Bill 1077, is in the Senate, and it's awaiting assignment to a committee in the Senate. So I hope that happens soon. I don't know what the details are there, what the timeline looks like, but I hope that the House bill makes some progress in the Senate, unlike last year when a similar bill passed out of the House and was killed behind closed doors in the Senate. Interestingly, this year, the Senator Liz Brown, who had the House bill assigned to her in the Senate, she was the committee chairman. She did not give constitutional carry a hearing or a vote last year and killed it behind closed doors. This year, she actually authored her own bill in the Senate, which seemed promising, but bizarrely, a few days ago, I believe it was Wednesday, the Senate had a hearing on her bill, and she seemed very opposed to her own bill and seems likely to kill it. So I don't know what kind of politics is going on, but it seems like she wants to have her cake and eat it too, so to speak. She has authored the bill, so she's got her name on it, but seems like she wants to kill it behind closed doors. And I don't know. I don't think her constituents are as ill-equipped as she may think. So to say that, hey, I authored this and then kill it behind closed doors seems like she's trying to pull the wool over the eyes of the voters. Yeah. And I hope that's not what's going on, but that's certainly what it seems like.
Yeah. And one would hope that if that is the case, the voters sniff that out and do the proper thing come the next election.
And unfortunately, what a lot of these politicians are doing in Indiana and in other states is they're trying to maintain their NRA A rating, right? Mm-hmm. So they come out and publicly support these pro-gun freedom protections, but then secretly behind closed doors don't support these bills. So they're doing whatever they can to support their A rating to help them in re-election campaigns. but doing everything they can on the other hand to not support freedom and the rights of Hoosiers behind closed doors. So I hope that that kind of information comes to the public light, and obviously we'll be talking about that more on the Daily Bulletin and the Weekly Bulletin in the future. So if it's okay, Paul, I'd like to actually read an announcement, read part of an announcement, not the whole announcement, from the 2A Project, which is an Indiana gun rights organization, and this was actually relatively new information about an hour ago.
Sure.
It says the 2A Project has confirmed that Governor Eric Holcomb is directly behind the efforts to kill constitutional carry in the Indiana Senate. This isn't a huge surprise because Doug Carter, the superintendent of the Indiana State Police, has publicly opposed constitutional carry, and he is appointed by the governor. This is interesting because just a few years ago when the NRA annual meeting was in Indiana, Governor Holcomb signed a few pro-gun bills into law, a self-defense immunity bill and a church carry bill, and he said there is no stronger state on the Second Amendment than Indiana. And I think that's a pretty laughable statement at this point. Indiana has a supermajority, Republican supermajority, and they've yet to pass. There are 21 other states who have passed constitutional carry before Indiana. So I think that's a very laughable statement. And I just want to bring light to that. If you're from Indiana and you can get involved, contact your representatives, let them know that you expect them to support constitutional carry. And I would contact the governor in his office, and also Senator Rod Bray, the president pro tem of the Senate, and Senator Liz Brown, to let them know that, hey, we're going to hold them accountable and not get away with these shenanigans in the Senate behind killing freedom behind closed doors.
Yeah. I want to make sure. No, I want to. Glad I checked because they were about to obliterate. I want to get a comment in here, but I had it going to the wrong place. We've got it correct now. Let me get. Charlie Chambers says, how many states now have constitutional permitless carry, and how many states are in the queue to pass in 2022? Well, Charlie, there are 21 at this exact moment in time. I know Indiana's working on it. Georgia and Alabama are working on it. Louisiana is making noise about it again, although Louisiana's governor, it did pass, and Louisiana's governor vetoed it last time. So they've got to pass it, but pass it stronger.
And I believe it's still on the table in Ohio. Have you heard anything in that regard? Oh, okay.
I have not heard anything.
I haven't heard anything recently.
Nebraska, I know, our neighbors to the south keep sending me reminders, hey, we're working on it, we're working on it, we're working on it. Yeah, you get it passed. I don't mean to sound negative, but I've heard that every year from Nebraska. And every year, Omaha and Lincoln stomp on it. And I hope this is the year they get it done. I really, really, really do. But, yeah, it will...
Well, I'm starting to feel like that in Indiana, that, we're getting so close every year, and even with the Republican supermajority, it dies every year. So hopefully we can get it over the finish line this year, but I'm starting to feel the same way as you do about Nebraska.
Yeah. So let's see. But I think, honestly, if you exclude the states on the coast, almost everybody west of the Mississippi, with the exception of Nebraska, has got constitutional carry.
Mm-hmm.
So, North Dakota, South Dakota, although North Dakota is for North Dakota residents only. If you are going to North Dakota, and you've got to have a permit from wherever you're at, but they recognize everybody's permits. So, but North Dakota, South Dakota, skip Nebraska, Kansas has it, Oklahoma has it, Texas has it, New Mexico, yeah, there's the flaw in my plan. New Mexico does not, Colorado does not, but Wyoming and Montana do. Idaho certainly does.
Mm-hmm.
And going back down, Utah, I don't know if I mentioned them, they do. and
Missouri. Did you mention Missouri?
no, that's east, but they do. No, Missouri. I'm trying to remember. I'll have to go to handgunlaw.us, but we're getting. Let me get a couple more comments in here real quick before we do that. Smeggy says, that's why I hate when people talk about 2A as a Republican Democrat issue. He says, it's a pro-freedom, anti-freedom issue. Yeah.
Exactly. There are plenty of Republicans opposed to freedom, and plenty of Democrats in favor of it in certain respects anyway. So it's a good way to look at it. It's a freedom versus anti-freedom issue.
And in his next comment, I think his tongue is firmly planted in his cheek. I'm just really worried about all the Wild West blood in the streets we keep hearing about. Yeah, don't hold your breath on that one, man. It's going to be a while before you see blood flowing in the streets of constitutional carry states. I want to get one more. I want to go to our next story. Where did I put my show notes at? There they are. I want to talk to you. I sent this article this morning. There's a county in North Carolina, I believe it's Greenville County, North Carolina. They've got currently there is a law that in the county law enforcement cannot enforce federal gun regulations, but they've taken it a step further, and apparently the way I was reading this morning was that anybody, not just law enforcement, anybody enforcing or anybody restricting, let me go back and see if I can find it in here again, because I don't want to mess this up. Greenville County already has a law in place that declares the county supports the right to bear arms and opposes any effort to regulate or constrict gun ownership. The new item proposed Thursday is merely an amendment to that law, which adds a specific punishment. That punishment/penalty is something our neighbors spoke out overwhelmingly in favor of Thursday night. So I don't know, man. This brings up the whole, sanctuary state, sanctuary county, all that. I guess it wouldn't hurt for us to go over a primer on this again, Alex. Where does, if the federal law says that you cannot rob a bank, right? Mm-hmm. If my county says it's okay to rob a bank, federal law outranks that, right?
Yeah. So there's supremacy. There's what's called the Supremacy Clause, which is just the idea that the federal law is supreme over state law if the two are in conflict. Okay, and the same holds true to some extent, depending on state law, with respect to state law versus local laws, so municipal ordinances, county ordinances, things like that. But the sanctuary movement is a little different because it's more of so much a conflict of law, but it's saying it's a policy statement where the local officials are saying, listen, we understand what the federal law is, but we're not going to enforce it in our county or in our city. And so that really hinders the effectiveness of the federal law, because there simply aren't enough federal law enforcement agents to enforce the law. And so they rely on state and local law enforcement to do their bidding. And so it's more of a policy statement saying, hey, we're going to protect the rights of our citizens. We're not going to enforce these unjust or unconstitutional laws as we see them. So, but then there's also this separate concept in the law called preemption, where a state, Indiana has this, says that local governments can't make laws that are more burdensome on your right to keep and bear arms than state law. So it prohibits local governments from regulating firearms or ammunitions to a greater extent than state law does. So in Indiana, for instance, if a local government says you can't carry a firearm in a public place that you ordinarily could, like during a special event or something like that, then you would have recourse to sue that local government entity, and they would be really the teeth behind it is that you would be entitled to your attorney fees. So the normal rule is that each party is responsible for their own attorney fees, but Indiana has set up a provision that says if a local government infringes on your rights, your gun rights, more than state law, then you have recourse and you're entitled to attorney fees. So that's another. So that's a separate concept from the sanctuary movement, but it's called preemption, and I think that's a very powerful tool, and one that many states have adopted. I'm not sure on the number, but quite a few states have preemption laws.
One thing that spun in my head about when I read this, and I don't know, I didn't see it just now when I looked back, but the county law will not allow anybody to enforce federal regulations in that county. So theoretically, it sets up county sheriffs and deputies against agents for the ATF who may be coming in to enforce federal law. Mm-hmm. And what it says is anybody trying to enforce unconstitutional, what the state or what the county considers unconstitutional Second Amendment law, anybody trying to enforce that can be arrested and fined in the county. Well, that seems to me where that sets up a appendage measuring contest. Let's put it that way.
Yeah, I agree. Yeah, and my understanding is that the proposed amendment would, like you say, it would subject anyone who violates Second Amendment rights to spend up to 30 days in jail or a $500 fine. So it's not a light penalty.
Right.
So you're right, but it could set up this conflict between local law enforcement and federal law enforcement potentially.
Yeah, God bless them. I just don't know how smart it is for a county to go against the federal government that way. Mm-hmm. I certainly wouldn't want to get into that kind of match.
Right.
Let's see here. And get this one up from Charlie Chambers. Charlie says, grassroots North Carolina is awesome. Pitbull for self-defense rights in North Carolina. Can do more for arms rights. Still better than New York, New Jersey, and California. Yeah, they are.
Yep.
Yeah, they are. All right, let's see. What do we got next on our hit parade of stories? Oh, for the first one I had up, SAF wins again in California. This is kind of about a temporary win, though, because even the Ninth Circuit handed down, said, yeah, it's not legal to shut down gun stores just because you think it's time to shut down the gun stores. You perceive it as a public health threat. That's against the Second Amendment. You can't do that. A 3-judge panel said. One of the 3 judges says, yeah, this is probably getting overturned when it goes en banc. So...
Yeah, that's right. And my understanding is that the gun shops were closed for about 48 days. Uh-huh. And, that's a significant burden on people's ability to exercise their rights if they can't buy guns or ammunition. So the court said it was an unconstitutional regulation that violated the Constitution. But you're right, it'll probably get overturned in the en banc review. But I thought that I saw the SAF statement about the issue, and Alan Gottlieb, I think his statement was good. It was pretty succinct. He said both cases illustrate the egregious pattern of anti-gun sentiment among California officials. Mm-hmm. And he said officials in both counties offered no explanation or justification for shutting down gun stores and shooting ranges while allowing hardware stores or bicycle shops to remain open. And neither hardware stores or bicycles are mentioned in the Constitution. So it just shows how our individual rights are seen as sort of second-class rights, especially when it comes to guns. So I thought that was a great statement from Alan Gottlieb, and I hope these cases can make some headway further down the road. So we'll see. And it'll be interesting, because the other thing that came up in these cases was what standard of review to apply. And the court said that under strict scrutiny or intermediate scrutiny, these would fail. And that will be an issue that will be addressed, hopefully, by the Supreme Court case in the New York State Rifle and Pistol Association versus Bruin case that we hope to get a decision on here in the next few months.
Right.
The Supreme Court should address what standard of review should apply. Should it be some interest balancing test like strict scrutiny, intermediate scrutiny, rational basis, or should it be a text history and tradition analysis? And clearly, closing down gun stores doesn't fit any sort of text history or tradition in the United States. Just because there's a natural disaster or a pandemic doesn't mean you lose your individual rights. If anything, that's when they're most important. And the court recognized that in these two cases.
Absolutely. Just because there was the one I like to draw the parallel between is the First Amendment. They didn't go in and shut down websites. They didn't close newspapers. They didn't shut down TV stations or radio stations. They never moved at all for the First Amendment, although they would if they thought they could. Believe me, they'd do that in a heartbeat. They would have me shut down in about 2 seconds if they thought they could.
Which raises a great point. I mean, even though there were no laws, there was enormous pressure on tech companies to censor certain information that didn't fit the government narrative. Is this misinformation? If it does this information not fit the government narrative, and if so, it should be censored.
Yeah.
So they were towing on that line, even though there wasn't an explicit regulation.
Absolutely, and that's why this show went podcast, is because it is being so severely throttled, both on YouTube and Facebook. So let me see here. Wow, I had to jump over, and I wasn't looking at comments. I want to get going back to the previous story. Smeggy had a comment I want to get up here. He says, "Good for them, but I'm not going to be the first person to bait the ATF in that county."
Right. Well, and that's the thing. We may not know what will happen with this amendment until the rubber meets the road, so to speak, until there is a conflict or till it is enforced against someone.
Yeah.
So we'll just have to wait and see. But
so let's go. We got one more story I want to get to here. Let me find. There we go. Tennessee has a bill. The sponsor of the bill is named it Kyle's Law, and it's if you are tried and found not guilty, you have the opportunity to get your defense paid for, at least your attorney's costs paid for. And I mentioned this when I did my solo show yesterday. I like the idea of the bill, but I want it passed on a little. I want it a little stronger than this. Speaking from personal experience, if the state's attorney brings charges against you and pushes, and then all of a sudden realizes, hey, this is a loser, I don't want to have this go against my win-loss record, and drops charges, guess what? Kyle Rittenhouse is still out. Kyle Rittenhouse was out hundreds, I'm sure, of thousands of dollars in attorney's fees. Mm-hmm. When I was falsely accused, I was out tens of thousands of dollars, and the charges were dropped. Oh, gee, we're sorry. Drop charges. You can go on about your way now.
Mm-hmm. Yeah. And there's no consequences to the prosecutor, right?
No,
I mean,
none.
None, zero. Um, Andrew Branca talked about this concept of Kyle's law after the conclusion of the Kyle Rittenhouse trial, and I thought it was an interesting idea at first, and I've come to like it more and more the more I thought about it. But the idea, you kind of have to understand the dynamic of a self-defense case, right? So in a self-defense case, if you assert self-defense, the state, the prosecutor, has to disprove self-defense beyond a reasonable doubt, okay? And if they fail to disprove self-defense beyond a reasonable doubt, the jury is supposed to find you not guilty. And as we saw in the Kyle Rittenhouse trial, that was largely motivated by political purposes, right? So, I mean, the evidence seemed clear that Kyle Rittenhouse acted in self-defense. So not only was it clear that he acted in self-defense, it was clear that the state could not disprove self-defense beyond a reasonable doubt. And in cases like that, the way that Andrew Branca proposed Kyle's law was that the jury should also then be asked, could the state disprove self-defense by a preponderance of the evidence, which means more likely than not, okay? And if the state couldn't even meet that burden, then the prosecutor and the county would be on the hook for your damages. So your attorney fees and whatever other damages you could prove, which may include mental and emotional distress damage,
Right.
which are huge in a case like that. So, but the key, I think, is to make prosecutors personally liable in situations like that. Otherwise, they suffer no consequence whatsoever. And in fact, in a case like the Rittenhouse trial, the prosecutor, I mean, he may get some benefit from pursuing this egregious prosecution because he's getting political points from the people that agree with him, who don't like individual liberty, who don't like guns, who don't like the concept of self-defense. So he may be getting political points by pursuing this prosecution, which is the only reason he would pursue such a prosecution. So I think making them personally liable is the only way to prevent that. And that's the idea behind Kyle's law.
I totally agree that the prosecutor needs some skin in the game.
Mm-hmm.
Why do we get these wild prosecutions? Because it's beneficial, honestly, for the prosecutor. There's no downside, and there can be huge upside.
Yeah.
So.
Yeah, the justification behind prosecutorial immunity is that we don't want prosecutors to fear personal liability for having prosecuted a case, because then they won't zealously prosecute criminals, right? But the problem is too many innocent people are caught up in the wheelhouse of the criminal justice system, and prosecutors prosecute those innocent people with impunity, and that's a huge cost to a system in an effort to prosecute criminals.
Larry says prosecutors routinely lie to juries about the offense and their actual burden, as well as prosecute for the actions which constitute several felonies, including perjury.
Yeah, there are obviously not all prosecutors are honest, but there's also a burden on defense counsel to do their job in pointing those sorts of things out and objecting and preserving error at trial for appeal and things like that. So there are mechanisms in the trial process to help alleviate those concerns, but it is a problem, unfortunately.
Yeah, and here we were just about down to the bottom of the hour, but I want to bring up prosecutors aren't going to get a whole lot of love here, because we get prosecutors like prosecuted Kyle Rittenhouse, where it was obviously self-defense and the guy was making a huge stretch, and prosecutors like in the George Zimmerman case, where it wasn't as clear cut, but it was still fairly clear cut that it was self-defense, to the point where he wasn't, the police never charged him. It was the DA that made sure he got charged. And by the way, she went on for a political career and basically built her political career off the Zimmerman case. And then we get DAs like are in Manhattan right now, where you've got to do something right on the edge of terrorism, and I mean real terrorism, where there are multiple deaths in order to get arrested and spend the night in jail. And we're not guaranteeing 2 nights for that.
Yeah. That's a great point. There are good prosecutors, of course, but unfortunately many of them are not in the job or in their role for the right reasons. A lot of times they're in there for political purposes, and they're trying to advance to the role of a judge or a governor or attorney general or something like that, and often prosecute cases for the wrong reasons. But there are prosecutors, I'll qualify the statement, that do take their role seriously, that do try to protect their communities, that do try to uphold their oath to the Constitution of the United States and their respective state, and to do the right thing. But that's not always the case, and often isn't the case, unfortunately.
You bet. Well, we just shot past the bottom of the hour, so that's going to be our time for today. Alex, thanks so much for joining us today, man.
Great to be with you, Paul.
I do want to remind you, if you're just happening to stumble onto the podcast, please subscribe, and we'd love to continue to grow, so please share it with a friend. If you happen to be watching us live, thank you. Thank you for doing that. And let everybody you know that we are now broadcasting over on the Polite Society podcast page every weekday at 5 p.m. Central, the only time zone that matters. Thanks again for watching, everybody, and we will see you next time.